Okay, this is a matter before the State Board of Land Commissioners in the state of Idaho in the matter of the encroachment permit application number L-95-S-6193, Adam and Coral Olinger, Alex Hamill, Jason Vedadi, and Jordan Dascalo as applicants, Scott Hansen with Lancome Marine as agent for applicants, agency case number PH 2026 NAB 22 003, Office of Administrative Hearing, case number 26 320 05. I want to make sure that folks online can hear us okay. Normally I do that before I read us into the record, but I stepped over it. Ms. Medseeker, can you confirm whether you can hear us?
Yes, loud and clear. Thank you.
Thank you. All right, well, we had a little bit of a delay here today getting started. We were informed that there was a accident here in Coeur d'Alene that was causing traffic backup. We wanted to make sure that everyone had sufficient time to get to this proceeding. We've also had inconsistent GPS directions given depending on what information you put into your GPS system. So the hearing was noticed for North Idaho College, 1000 West Garden Avenue in Coeur d'Alene, Idaho, 83814. We have confirmed with the North Idaho College staff that that is the physical address of where the college accepts mail, and is not the address of the building we are in. The notice, however, also did specify that we would be in the Molstead Library, room 101, Todd Lecture Hall, which would take you to the correct building that we are in. Amity Fusion with IDL staff went over to the 1000 West Garden Avenue and confirmed that nobody was walking around lost that hadn't already found the building that where we are here holding the hearing here today. Another development, I don't think it made it into the live docket at this point in time, but there was a comment from the Kootenai County Sheriff's Office expressing safety concerns with this project. The captain with the Sheriff's Office came to the hearing before it began and turned in a comment rescinding that concern. So that will be added to the live docket as well. Another late occurring late occurring event was as of Monday, I believe, Tuesday, maybe it was, yes, it's Wednesday. So Tuesday, applicant had submitted an updated application that resolved the concerns that IDL had raised with the application and had resolved all of the concerns that the neighbor objection had with the application, and the objection yesterday was withdrawn. Additionally, this morning, I know that's not standard for some of you that have participated in these proceedings before. This morning, we conducted an on-site inspection of the property. The reason we did it this morning rather than after the hearing process is because of some time constraints with IDL's counsel, myself, and some other prior hearings that were scheduled earlier this week that we were also conducting in the area. So the timing just had us take things a little bit out of order than what we normally do. So those were just a few process things I wanted and updates I wanted to give to the audience, because otherwise you don't have a full picture at the time that you provide your comment. So with that, I will turn it over to Ms. Richter. For those of that you don't know, Kayleen Richter represents the Idaho Department of Lands. My name is Leslie Hayes. I'm the Deputy Chief Administrative Law Judge for the state of Idaho. With the Office of Administrative Hearings, we're a third-party neutral agency that adjudicates proceedings for state agencies, not just in the lands context, in any context with any agency at either their request or as required by statute. And then Lance Lane is here with Lancome Marine. Scott Hansen is on the phone calls but will not be participating remotely. He has delegated those duties over to Mr. Lane. So with that, Ms. Richter, do you have a witness you would like to call?
I do, and I just a couple more things to note. For the record, I am right now sitting with my line of sight to the doors. So if somebody comes in and they are looking for where we are, I will flag them down. And also outside, IDL posted a sign with indicating that the hearing is in this building, and that is out towards the street. And then the third thing that I wanted to note is that the site visit conducted before the hearing was done with the applicant's consent and approval. So
Yes, and I would say that the objector opted when they withdrew their objection not to attend the on-site inspection. So it was myself, Ms. Richter, and Mr. Lane.
With that being said, I just have Mr. Amer, and he will be presenting a statement.
Mr. Amer, I'll have you raise your right hand for me. Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay. Before we start, the on-site inspection, all photos and audio from where that occurred and what occurred will also be posted to the live docket for folks to review.
I was going to say, do you want this table?
Okay, so Ms. Hearing Officer and audience, Department of Lands already submitted a hearing statement that we will not be reading. That's part of the record. Everybody can see it on our website, but we did prepare an additional statement today that I'll be reading. In 2025, representatives from Kootenai County Parks and Waterways, the Kootenai County Waterways Advisory Board, the City of Coeur d'Alene Community Planning Department and their legal counsel, the City of Post Falls Planning Department, Kootenai County Sheriff's Office, and IDL met to review issues related to the Spokane River. At this meeting, representatives discussed the concept of a 366-foot navigation corridor on the Spokane River. The 366-foot corridor is a concept based on existing Kootenai County boating ordinances. Those ordinances require boats to remain at no wake within 100 feet of shore or a dock. They also require boats passing one another to maintain approximately 50 feet of separation. Given that many boats average approximately 8 feet in width, this results in a minimum corridor of roughly 366 feet to allow for safe navigation. This distance would apply whether measured from dock to dock, bank to bank, dock to dock, dock to bank, or dock to encroachment, or any similar combination. Based on aerial imagery of the project area, before any new docks are installed on the south side of the Spokane River, the distance from the south shore to encroachments on the north side currently varies from approximately 510 feet to approximately 310 feet. The encroachments on the north side are primarily relic piling from the former log mill operations, along with log booms that protect the public swimming area. The relic piling are located in front of City of Coeur d'Alene property, specifically the Atlas Mill Park and swimming area. The city's property includes a public swimming beach, ADA accessible water access, a dog swimming area, and trails overlooking the river. Since the city acquired the upland property from the former mill site's owners, and because the piling are located within the city's littoral area, IDL's position is that the responsibility for the piling and any potential removal rests with the City of Coeur d'Alene. If the relic piling are removed, the distance between the south shore and the north shore increases substantially. Following discussions with the Kootenai County Marine Deputies and Kootenai County Parks and Waterways, it is IDL's position and recommendation that the relic piling be removed regardless of whether this application is approved. Again, removal of the piling would increase the usable width of the Spokane River and improve boater safety. If the relic piling remain in place and the application is approved, the channel width across the river would approximately be 339 feet at the Vedadi dock, 309 feet at the BWHQ LLC dock, and 323 feet at the Hamill dock. The Olinger dock would remain unchanged and would continue to provide approximately 406 feet of channel width. While 3 of the 4 docks would not provide the full 366-foot corridor, the proposed dock designs generally stay close to shore and are more similar to boardwalk style docks. The Vedadi dock would extend approximately 40 feet into the river with no ramp or approach. The BWHQ LLC dock would extend approximately 36 feet into the river with no ramp or approach. The Hamill dock would extend approximately 56 feet into the river with an approximately 15-foot ramp approach. A littoral owner's right to wharf out and access the waters of the state is well settled in Idaho law. Under Idaho Code 58 20-1302 and IDAPA 20.03.04.01.32, riparian and littoral rights include the ability of owners adjacent to navigable waters to build and use aids to navigation. IDL does not have the authority to completely prohibit a riparian or littoral owner from wharfing out or constructing a dock. However, IDL does have authority under IDAPA to limit the size or square footage of a proposed community dock. IDL used its authority when processing this application by working with the applicants to design a mutually acceptable community dock system that stayed close to the shoreline, especially where the river's navigable channel is narrowest. In this case, the section of the Spokane River where the Vedadi, BWHQ, and Hamill properties are located does not currently provide a 366-foot corridor because of the existing relic piling. Therefore, unless the piling are removed, any structure placed in this area would further reduce the available navigable width. If the relic piling are removed and the proposed docks are approved, the Vedadi dock would provide approximately 425 feet of channel width. The BWHQ dock would provide approximately 346 feet, and the Hamill dock would provide approximately 356 feet. The Olinger dock system would remain at approximately 406 feet. Although 2 of the 4 docks in the community dock system would still not meet the full 366-foot corridor after removal of the piling, the overall navigable width of the Spokane River in this area would still be greater than it is today. It is also important to note that at the narrowest point in this area, just west of the Vedadi lot, there is currently only approximately 244 feet of navigable channel between the south bank of the Spokane River and the relic piling that extend into the middle of the river. However, even though there is only currently 244 feet of navigable channel, the Kootenai County Sheriff has not designated this section of the river as a no-wake zone. While the application appears to satisfy the minimum standards, the director must also weigh the detriments to the lake value factors against the potential benefits. IDL's position is that unless the piling are removed, the proposed community dock system would likely have a detrimental effect on the lake value factor of navigation. IDL is concerned that approval of this application would cause the Kootenai County Sheriff's Office to designate this section of the river as a no-wake zone. However, IDL cannot control the Kootenai County Sheriff's Office actions, and the littoral owners have the right to wharf out. And we will submit this as part of the record.
Thank you. And then you address the pilings that are in the middle of the river, just to the, is that to the south of?
To the west of
To
the
the-
Vedadi dock.
The west.
Sorry, I'm trying to share. We also have pictures.
They
That looks
give
like
you
I'm-
permissions?
Yeah, well, I'm sharing partly. It might be, I don't know what's happening.
We don't either.
It was glitching a minute ago, so I think it was trying to share.
I'll see, I'll stop and try again. But we can also submit.
So the pilings, are you gonna ask a question specific to those based on your picture? Okay. Has part of the conversations with the city of Coeur d'Alene on removal of the pilings on, I'm turned around, is that the south side of the river?
So if you're
Or the
looking
north
at
side of the river.
so if you're looking at an aerial view, the project is on the south side of the river.
Right, and the park is on the north side.
Park's on the north. The Vedadi dock is the far west, and the Olinger dock is the far east. So the piling that stick out the farthest that are in the middle of the river are to the west of the Vedadi dock.
Okay, and have your conversations with the city included removal of those pilings?
There have been discussions with them as well.
The subsequent owner of the upland property that installed those pilings originally?
Correct, way back in the days of the log mill.
Okay. That was the only question that I had.
And our statement and the figures we created with the distances will be placed on the record that the public can view on the IDL website for this hearing.
I wonder if I share it, it'll work. Let's briefly, we're gonna briefly take a break to see if we can get the video or the photo to share to folks participating online and also here in person. So bear with us.
I don't know if you can draw that one.
No, I'm not gonna draw.
I'm
I'm not gonna. It's disappointing.
All right, we are back on the record. We have the screen shared. Mr. Amer and Ms. Richter, the floor is yours.
Yeah, that was
Okay. Okay, so what we're looking at are green lines that go across from the river. The green lines on the south shore of the river are approximately at the ordinary high water mark, and then they shoot across the river to encroachments that are currently in place, and that shows the distances. And there are 4 lots that make up this community dock system. On the screen where it says 9496, that is the Vedadi lot. Where it says 100 on the screen for the address, that is the BWHQ. And then to the right of that is Hamill, and then the far right is the Olinger dock. So on the Olinger dock, you can see that it's about 509 feet from the shore to the log boom that consists of the Atlas Mill Park swimming area. Moving over 1 lot to the west, you see that's 354 feet from the south shore to existing piling. And then moving 1 more over where it says 100, it's about 339 feet from the shore to piling. And then on that far west lot, there are 3 lines because there are 3 different encroachments into the water. I did not create a line, but the far left line where it says 312, if you were to project a line from the piling in the middle of the river to the point that is on land, that is the 244-foot distance. So right now there currently is a 244-foot distance from that projection on the south shore out to that piling. That row of piling is relic piling from the log mill days. All of the logs would float down the river to the west, and then they'd be corralled into that area. As boats are traveling on the west part of the river, if a boat were to inadvertently go north of those line of piling, they would be contained in a small little area and they wouldn't be able to shoot out unless you're a daredevil and you are able to shoot the gap. You have to travel to the south side of those piling where both lines of traffic would be coming. So this was a figure that was created showing what is currently there now with no encroachments on the south side, and also showing what the distance are with those old relic piling in the water. And the other figure shows what it would look like with if the piling were removed. So the bottom one. So again, we're looking at the same view in the same area. I tried to create the lines in the same exact location. Again, on the far right, the Olinger dock is still the same distance because that log boom protecting the swimming area will not be removed. That was an encroachment that's been permitted to the city to protect that swimming area. There's a little blue square up north there. That is the ADA accessible ramp. So that log boom won't be moved.
Right here.
Correct. The next lot over to the left where there's 3 lines. If the piling are removed, then there would be 3 distances to potentially measure. The right one would be 443. That would go to that log boom previously described. The one in the middle that says 491 shoots all the way across to the other side of the river. And then the one that says 412 shoots over to another log boom. Moving 1 lot over to 100, it says 382 feet that would go to that log boom. And then going over to the Vedadi dock, if those piling that were in the middle of the river that we previously discussed, if those were removed, you can see that it's either 465 feet across, 528 feet across, or about 620 feet across. So what the purpose of those figures, what I was trying to show with these figures is that the way that it is currently set up with the previous figure, there currently is not a 366-foot corridor existing in this area already. And so obviously any dock that got put in would further exacerbate that situation. But if the piling were to be removed by the city of Coeur d'Alene, it would greatly open up the entire river for wider navigation. And then also just to point out that, again, there's 244 feet from that piling to the protrusion. And currently this whole zone is not currently a no wake zone. Also wanted to just point out for the record, the 366-foot corridor is not an ordinance. It is not a law. It was something that was discussed amongst agencies when we're discussing the amount of applications and projects on the Spokane River and the best way to try to manage that system, all of those heads got together and talked, and that's how we came up with that number. And again, that number would be in an ideal situation. We had another hearing at the River's Edge Apartments where the Marine deputy mentioned that if someone was in the water, if there was a kayaker, if there was a log or debris, then that would make that situation where you need more than 366. So 366 would have been the minimum.
So Mr. Hamer, where we see from this 100 property, the 382, is that part of the swim area too, of why it's not going all the way to the shore?
No, that's a good question. I don't believe that's part of the swimming area. I from my own personal recollection, I don't recall. I definitely know that where the blue square is the ADA area. And then if you go downstream a little bit where there's another sandy beach area, that is the dog swimming area. So this is a dog beach. And then for some reason, downstream of the dog beach is where people swim. And I believe this could be leftover relic, but it looks like it's about the same distance. I speaking with the city, don't want to speak for the city, but speaking with the city, I don't believe they would be inclined to remove this because there's also a stairway and like a little amphitheater and a little beach right here for people to access. So I don't think they'd have any interest in removing that piling. But the other piling that were on the other figure are definitely relic piling from the mill days, and I don't see a purpose for them anymore.
And then with this 382 feet, the proposed length of the dock at the 100 property, would that still make that a 366-foot corridor, or would that be short? Because I know when we talked about it previously, we had the length of the dock, the length of docks on the other side of the river, if ever requested, and then 366 still remaining in the middle.
I believe that this dock is proposed to be 360. This dock was proposed to be 36 feet in length. So you would do the math. 382 minus 36 is what would be remaining at that point. I think it was 356 is what this one was, and this one was going to be 346 when I did the math. Also want to point out that where these green lines are located is where the proposed docks would be. That's why I chose those locations. I didn't choose somewhere else on the figure to give me a better number or a less number. I chose those locations because that is where the docks are being proposed.
Okay, that's helpful. Thank you.
And for the record, the documents, the pages that I provided you with the revised application, and Mr. Lane may want to clarify this, but the smaller packet, which is the isolated changes to the application, the applicant did provide, IDL requested, and the applicant provided their measured distances from the proposed encroachments. Their proposed encroachments to the impediments in the river.
Okay. All of which you'll cover for me in post-hearing briefing?
Absolutely. Hard to do all these numbers.
Yes, especially with changes. Okay, Mr. Emer, I don't have any other questions for you. Do you have anything else you'd like him to present?
No, thank you.
Thank you.
Does the applicant have any questions for Mr. Emer? Okay. Do you have any additional witnesses, Ms. Richter?
I do not.
And then, Mr. Lane, did you want to present anything in addition to what's been presented by IDL for the applicant? Okay. So with that, we are to the public comment portion.
1 moment to move.
Yep, we'll give Ms. Richter a moment to move into the audience. We'll get the lights back on. And I'll call my first person up so that they can get situated and ready. I have Scott Schofield.
Yeah.
You can stand. If you're more comfortable sitting, you can sit. Okay. You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth. Okay, and then please state your name, but spell your last for the record.
My name is Scott Schofield, and it's Schofield. So this is the fourth public hearing that I've attended to and spoke at over the last year and a half, trying to present some safety and some common sense to a very much river that's either reached maximum capacity or it's right on the brink of reaching maximum capacity of the usage. And it seems that there is just no attention being paid to the public safety of what's going on in the river. We've had a number of anecdotal situations and cases and enough evidence that should be provided to where actually to the point that we're still in litigation on the very first project that we're in, and we're going to be going to the Idaho Supreme Court to deal with that one. So we got involved in this one just a little bit. So I do have some things that I'd like to read and suggest in relationship to some of the code and some of the failures that I'd like to suggest that maybe a part of what's happening here. The first one would be failure of technical documentation. I'd like to suppose that under Idaho Code 54-11202, the determination of the ordinary high water mark and the projection of the littoral right lines are considered the practice of land surveying. This applicant lacks a certified survey bearing the seal and signature of a licensed Idaho professional land surveyor. Without a stamped survey, the department cannot legally verify the 10-foot side yard setbacks required by IDAPA 20.03.04.015. The department is currently accepting conceptual sketches in place of mandatory authenticated technical data. The question kind of arises out of that is, has the IDL employed a certified surveyor?
So Mr. Schofield, you said 54-1202. Do you mean 58-1202? Which would be the land statutes?
I have, when I got it, I looked at 54, so maybe it is 58.
Okay, I'll check both.
Okay.
Yeah.
Okay, thank you. Second, illegal moorage density. The IDAPA 20.03.04.015.02.c.ii or 2 strictly limits community docks to 2 moorage sites for each littoral owner. This application proposes a density of up to 6 slips per residence. This is an indisputable violation, I feel, of the department's own administrative rules by processing this as a quote community dock. IDL is bypassing the commercial marina public benefit test required by IDAPA 20.03.04.010.06. Question
01004.
20.03.04.010.006. I should say 0 instead of 0. Sorry.
06. Okay.
Yes, sorry. So the question kind of arises out of this. Is IDL honoring their duty to weigh benefits versus detriments on the Spokane River? Are they honoring the public trust doctrine? Third and final one that I have that I'd like to share is navigational safety and federal oversight. Idaho Code 58-1306 mandates the denial of any permit that unduly interferes with navigation. This project is situated at a documented navigational choke point. The applicant has provided no navigational impact study nor engineering report on sediment disturbance. The scale of this project triggers a U.S. Army Corps of Engineers Section 404 oversight, yet no federal coordination is present in the record. So, conclusion, I'd like to say that accepting a technically deficient application that violates moorage density limits is an arbitrary and capricious agency action. I would humbly request, so I've been at this for a year and a half now, dealing with trying to get the public trust of our community river and the safety as something that the IDL pays attention to, and not just signing these things off, that they would request the department to stay these proceedings until a certified survey and a navigational impact study are submitted for public scrutiny.
Thank you. Thank you, Mr. Schofield.
Mr. Mayor, make a comment or address that, or do you want me to just do it? And I just want to note that there is a survey.
In the revised application?
I meant definitely in the revised application at page 31. They're not being stamped. I don't have enough hands to try and find that.
Well, what I want to do is I want to break to give Mr. Schofield an opportunity to review the revised application since it came in yesterday.
I'm sorry. It is also in the original.
It's in the original application. Oh, okay.
IDL 01, page 3.
Page 3. They're not numbered.
They are in IDL 01.
I'm gonna hand him the new revised.
Yeah, let's go ahead and take a quick break so that Mr. Schofield can take a look and decide if he wants to extrapolate on his public comment. So we'll be off the record here for a few minutes. All right, we are back on the record in these proceedings. I had just excused myself from the room for a few minutes because some audience members had questions for IDL staff. Rightfully so, in my opinion, it's completely inappropriate for me to accept evidence that's not part of an official record in these proceedings. So for those informal conversations about processes and procedures to occur, I excused myself. And we are now back on the record. Mr. Schofield, when we left it, I had IDL give you a copy of the original application to address some of the comments that you made. And so I would like to open the floor back up to you if you would like any modified comments or additional comments at this time.
I mean, I can't totally tell from the survey.
So minuscule.
But it is what it is. I'll just leave it there.
Okay. And then the next on my list for public comment, I have Sherry Schofield. Schofield, have you raised your right hand? Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Okay. The floor is yours.
Okay, I would like to say that we were presented with this survey, but it is so minuscule, you can't even read it, and it doesn't appear, I'm not a surveyor, but it doesn't appear to actually show well the other side of the river. And it also, I am going to say, the objector had said there was only 238 feet that she measured, and I thought it was with an instrument, not her eye. But but you said you have the minimum amount that two boats can pass, but why are we going for the minimum amount? It's not often there's only two boats. We're talking paddle boarders, boaters, fishermen, 3, 4, 5 boats. As we said last summer, we were almost impacted with 5 boats going past. So this was still, if you notice in the 3 lots, they'll say, even if they remove the pilings, which is so helpful, and it will still make a choke point that isn't safe. And so the two lots that were on this side, all the lots that were
You want me
east.
to put back up the picture?
Yeah, please. The lots that are to the east and they are undeveloped, they are in a very narrow portion as well, and they haven't applied for any docks yet. So look how this goes down here, but if they get the docks, then they get the docks. And so these three still, even with the pilings removed there, it's still a choke point. That's better right there. But that is without the docks even installed. And that's a 70-foot dock, a 56-foot dock, a 40-foot dock, and a 36-foot dock. So that's without, you're getting those measurements without even the docks being installed.
So I want to clarify for the record, because the transcript doesn't recognize theirs and
Yes,
yours,
I'm sorry.
that the narrow channel of additional docks on properties partially developed yet or yet to be developed is to the east
Yes, east.
on the south side of the river.
Correct.
And that it's your testimony that the spacing for properties, remind me the first property's name? Olinger's property, the 100 property, and the one between Olinger and 100. Do you think that spacing is
I still think all of them. Let me say all of them.
all of
Yeah.
the spacing is too dangerous on all four properties? Okay.
With or without the pilings removed. And so I say that there will still be oh, I already said that. Okay. So let's not forget in the summer how many deadheads pop up. I mean, that area is a deadhead zone, as is the whole river. So if we've got all these boats in this narrow channel choke point, and we've got deadheads that sometimes you can't even see, sometimes they pop up with just the head up first, and you don't see them. Sometimes they're laying straight, but that is just a disaster waiting to happen in such a narrow area. And there are a lot of paddleboarders and swimmers because all that area you saw is Atlas Park. It's Albert River. I forget which side, the 74 dock marina, the IDL already approved for River's Edge is, which is, I don't know if it's still in appeal or not, but that's another 74 boats right there. And this is just going to be a traffic jam. And so I also want to bring up a fact that when we're still disputing Templins up there where Stancraft is trying to take an extra 2 acres out to the old pilings, and that is public water. So one of our supporters or concerned citizens mentioned that pilings, there has been lawsuits over who owns the pilings wherever they are up and down the river. And I find it so convenient now that IDL is willing to take out the pilings and without any studies or anything about even, I mean, what is that water disturbance going to be like? How long those pilings have been in there? So I said when the recording was off that the community dock definition says a community dock is a structure. One structure. One, not structures like these people are pulling off 4 different docks with 4 to 6 slips per dock, and most people have to do backflips and stand on their head in order to get work on their dock approved or their shorelines that are eroding because the mega traffic along the river. They can't even hardly get permits to repair their seawalls and shorelines. So that's, that's an interesting thing. And I would like to say that, safety is priceless. Safety is so important. Why are we going to give up safety and just allow, and pretty soon we're going to be walking from dock to dock on the north and south sides of the river because there's just, and I'm not saying people can't have docks because I know that will go against me as a strike against me. I have my dock. And so the thing is that we just have to think about how many boats, and weigh the carrying capacity and the shoreline erosion, all that stuff. So I would like to read this letter. The Kootenai County Sheriff's Office does not support any project that would reduce the navigable width of the waterway in an already narrow section of the river. This stretch of the river is actively used by a variety of vessels, and maintaining adequate space for safe navigation is critical. Constricting the channel increases the likelihood of congestion, reduces maneuverability, and elevates the risk of collisions and other safety hazards, particularly during periods of high recreational use or emergency response. Additionally, narrowing the waterway may trigger no-wake restrictions under existing county ordinances, which would further limit how the public can use and enjoy these areas. From a public safety and enforcement perspective, preserving the full navigable width is essential to ensure boaters can operate safely and responsibly, and that emergency vessels retain the access and space necessary to respond effectively. That was the letter that the Sheriff's Department removed and rescinded. Why? So my last point is that if they decide to make this a no-wake zone, that makes the other no-wake zones completely dense with traffic, and therefore that harms the shorelines and increases risks. And if your house is in one of those unregulated zones, and now 10 times, 20 times the amount of boats are there because they approved things too big in this narrow part of the river and had to make it a no-wake zone, you're going to have tons of boat traffic right in front of your house, eroding your shorelines. And
Thank you. And I did ask you to spell your last name, but I assume Schofield is spelled the same. Okay.
Scofield. Oh, I did have one more comment.
Okay.
I didn't feel that this survey that was added, I guess in the last, or some documents, something was added in the last 24 hours. And so that was a dispute we have, but I didn't feel that this survey is very, it doesn't show everything that, I mean, at least I can't recognize it. So the edges of the wall, all the shorelines and all the pilings and everything like that for the docks. Thank you.
Thank you, Ms. Schofield. And then I have Toby Sheldon. Do you swear or affirm that the testimony you're about to provide is truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please state your name for the record and spell your last.
Sheldon, I dressed for this occasion today.
Yes, spell your last name.
Spell your last name.
You want me to?
Yes.
Tobysheldon. All right, very
It
good.
helps when I'm writing the order.
I'm not good at this.
It's okay.
I'm just a hardcore skier. Used to be. and I lived on the river. Could you put that map back up, please?
Yeah.
I'd appreciate it. I lived on the river for 11 years. Mike knows that. And we have done a community dock. So I'm going to ask you a couple questions, Mike, maybe, hopefully we'll get a better understanding. I'm kind of late guy coming in on this whole thing, but I want, show me where the 70-foot dock is going to be. Which one will that be?
The far right.
Oh, over here, this one. So it's going to protrude 70 feet. Is that correct?
Correct. It's gonna be 70 feet inside the cove. So if you see where the green line is, it says
Right.
509.
Yeah.
It's gonna be in that cove.
So he's going out 70 feet,
Correct.
and they'll have a maximum of 700 square feet. Correct?
No.
Why? That's what everybody required of me.
Community dock is allowed 7 square feet for every lineal foot of shoreline you have.
Why are they considered a community dock if it's a single lot, like everybody else?
So it sounds like Mr. Sheldon probably needs some information from you, Mike, to be able to provide meaningful public comment. Would you be agreeable for us to go off the record, take a break so that he can ask these questions of you, and then we can go back on the record so he can provide his comments?
I think that the questions that he's asking were ones that we discussed when we went off the record before. And I don't, if that didn't answer your questions, we can do that again.
I'll withdraw the question.
Okay.
Put the questions into the record.
Yeah, you can put you can put the questions into the record of why this, why that, for consideration when I'm writing my order. But the public doesn't have the same rights to examine witnesses as applicants and objectors. But what you do have the right to do, and this is how I handle it in all these proceedings, is if you have questions about the process, the procedures, and the regulations, is IDL staff is here to talk to you off the record. Yes. But if you've already had these questions answered by Mr. Amer, then just say these are the questions that you have that you don't understand.
I don't understand my question then. Why? How?
Why is he allowed to have a 70-foot dock?
Right. Now, I personally did a community dock. 80 feet long, wide. Actually, it's 100 feet or 60 feet, excuse me, 60 feet with 80 feet at the river. And it's not a lot. It's a secondary access for lots above the river. Never did it come up that we could do a community dock on the lot that I developed and built a house upon on the river, 2010. Actually, I put 3 boat slips. They granted me that, but I kept it under the 700 square feet limit. I'm not quite sure if this thing has become somewhat convoluted in the application process. Quite honestly, John Magnuson should have been participants in this, in getting this permitted as a condition to the sale of the property. And I've used both of them, sadly. Okay, those are my basic questions that I think need to be addressed, should be evaluated. Now, from a real, everybody keeps talking about the practicality of this. Hardcore water skier, we moved on the river in 2000, left the river in 2011. My wife will never go back to the river for 2 reasons. The danger involved, and she hates the noise. It's awful. Back in 2000, I'm going to say 2003 or 4, where pilings were much more prevalent, prior to the time that Fred Finney pushed a bunch of them out. That was an awful spot. The traffic wasn't nearly as bad as it was, as it is today. If you get two boats going opposite directions, and then you have a third party that thinks they can get between them or around them with these high $300,000 wake boats, you're going to have serious problems. Even back then, I told my wife, somebody's going to get hurt in that particular area. I went to the meeting, and I think I mentioned this to you, Mike. I went to the meeting when the application for Atlas Water Park was being permitted. And I said, oh, what about the pilings? Nobody thought anything about the pilings. It should have been the responsibility of the people selling the property, or a condition of the acquisition of them, that those pilings should have been removed at the time. And that's a serious concern. Somebody is going to get impaled on something, whether it's an 8-year-old kid on a jet ski flying by his shorts that's not supposed to be doing it, but they do. Trust me, they do. I hope the consideration is given to the safety. I don't have a problem with everybody having a boat slip, but not a community boat slip for a single family lot.
Yeah.
Period. Thank you.
Thank you. Okay, that's all the individuals that I had signed up to provide public comment. If anybody else has changed their mind and would like to provide comment at this time, please.
I'd like to change your mind if I may.
Yeah, absolutely. Come on down. And what's your name?
Ron Hartman. I signed in. Hartman.
Okay.
The other thing that hasn't.
Can I have you raise your right hand for me?
Sure.
Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
What hasn't been mentioned with those two boats is what if one of them or both of them are towing a child on a 40 or 50-foot rope, and that child isn't directly behind that boat the majority of the time. I can't tell you the number of times I've driven through there when I've had somebody on a boat cut in front of me, towing a child behind me, and I've had to come to a complete stop. So it's more than just a boat.
Sorry, I thought it was the building.
Yeah, me too. So it's more than just a boat. It's the fact they're allowed to tow kids in these vulnerable float things behind them. That and God forbid one of the kids hit those pylons. Talk about impaled. I just think that needs to be considered along with it. It's more than just two boats. Thank you.
Thank you. All right, seeing no other eager participants, that concludes our proceedings. I have asked that IDL provide me with updated closing briefing, given some of the changes of the location of the docks and the measurements, so that I fully know what the as proposed distances are across the river when I'm working on my order, and not trying to calculate that math on my own, which can prove itself problematic if I don't have the accurate distances in front of me. I believe this application hearing deadline is April 15th. Ms. Richter, I know I piled a deadline on you yesterday. Would you be able to get that to me if we close evidence on April 15th by Friday the following week?
The 24th?
Yes.
That is what I was going to request, so yes.
Okay.
And I think, should you choose to hold the record open for additional comments, I think that would be appropriate. So folks that feel that they would need more time to process, to understand the application, will have that additional opportunity.
Absolutely. That was my intent, to hold public comment open till April 15th. Those can be submitted to the Department of Lands directly. Those will be considered, and then closing briefing on April 24th. Mr. Lane, your client is free to provide briefing if you desire to respond to any of the comments here tonight, to respond to any of the comments that may come in later. That obviously do not have to, if you do not desire to. So with that, we will be closed out here tonight. I appreciate everyone's participation. Not as many tech issues as last night. That's the good news, but I also appreciate you humoring us through a few tech issues that we had to work our way through. So thank you to everyone that's been online participating and everyone that's in the room.
Thank you.
Yes, thank you.